Vice Chair Ambrose.
Present.
Commissioner Lee.
Here.
Commissioner Smith.
Present.
Commissioner Lateef Gray has a conflict today and has an excused absence, will not be attending, but will proceed anyway. So agenda item number 2. The items appearing or not appearing on the agenda. I'll call for public comment. Here we go. Yes.
Thank you, Ethics Commissioners, and thank you, Ethics Commission staff. My name is Ellen Lee Zhao. You see my name tag in here. I am a public serving for more than 10 years. I am a union steward for government employees. You all know we have about 32,000 government employees. I am also the Director of Public Relations for the California Civic Grand Jury Association, the San Francisco chapter. I have been coming in here to report it to you in different dates back in 2016, 2017, 2018, and 2019. The last time I was here was October 18, 2019. I came before you, demand you as Ethics Commissioners and staff to investigate government abuse, government corruption within public officials. I have been reporting to you possible corruption within electoral officials through election fraud. No other party for 45 years. We have Green, Independent, Libertarian, Republican, Nonpartisan, or Constitution. But in San Francisco, we only have one party for 45 years, that is Democrats. There's no political equity for people. Pay to play, supported by Super PAC, matching fund. 2018, San Francisco taxpayers pay $4.16 million in matching fund to support Democrats that refuse non-Democrats to debate or going into forums. 2019, Democrats and all of you sitting in here increased more matching fund to create a more government scam. Democrats' agendas, also called socialist, globalist agenda, created 21,000 homeless dying on the street, 25,000 drug dealers and abusers supported by taxpayers. That is non-stop car break-in every day, violence, crimes target minority people like the Chinese people. 50,000 plus empty apartments available today, but yet the public officials selling more bonds to Proposition A to ask for $6 million for only 2,800 housing units. The liberals, called Democrats, has been operating a tyranny government for the last 45 years in San Francisco. The United States Constitution, Article 6, it is a violation for San Francisco to operate such a government to abuse its power. You know, sanctuary city and the sanctuary law is a violation for federal law. Recreational cannabis is a violation. Illegal drug, it's a violation, but those are all supported by Democratic agendas. 5 million free needles given free to drug people and rehab later for public money. I am here today to ask you, please, do your job investigation, restore a government that is for the people, supported by the people. I believe that you're personally liable for what you are doing in here. If you sign up for something, you have a duty to do so. Thank you. For public records, this is my statement.
Thank you.
Thank you.
Any other public comment? Please.
Hello, I'm David Lee. I'm here today because my campaign for supervisor in 2016, the treasurer, sent a request for a waiver request for late fees assessed on my campaign back in 2017, and we had not received an answer on that letter. However, this week I learned that we were asked to remit payment for the late fees. So I am asking that a formal response to our letter requesting a waiver be submitted to us. Okay, that's all I have to say. Thank you.
Mr. Lee, could I just, and Mr. Shen, Deputy City Attorney Shen, could you please guide me if I'm overstepping my Brown Act responsibilities?
Yes.
I just wanted to understand what you just shared with us, is that
Yes.
you ran for office in 2016?
2016,
Okay.
and shortly thereafter, we learned that my campaign manager, who was a paid campaign manager, campaign consultant, failed to file some documents, particularly related to mailers. I believe they were the 161 mailers, and we, working with our treasurer immediately, once we found that out, immediately submitted the late filings, uploaded them to the website. And shortly thereafter, we received a letter from the commission. I believe Ernestine Braxton submitted a letter requesting late fees for that filing, for the late filing, and we submitted a letter requesting a waiver or consideration, given that the campaign consultant was responsible for filing them, and we submitted also the contract that we had with the consultant, and the mitigating circumstances of that late filing, and the fact that as soon as we found out about it, our campaign found out about it, we immediately uploaded those required documents. And we had not gotten a response back.
To the waiver request?
Waiver, exactly.
And that was received in 2016 or
2017.
2017, okay.
So,
Fast forward to 2019.
yes, so this week we received a letter from, an email from Ernestine Braxton requesting the late fees be paid with no mention of the waiver request.
So you never received, okay. Thank you. And then.
So that's
go
why
ahead.
I'm here today.
Okay.
To ask for consideration, given that our campaign committee passed audit back in 2018 without any problems, except I think there was a small amount of the was not accounted for, but other than that, it did pass audit, and we do have a letter from your auditor, your independent auditor, saying that. So I'm here today to ask to see if we can have the waiver considered. Yes. Okay.
So Executive Director Pelham, I'd like to ask you to, take that further. Thank you. Any other public comment for agenda item number 2? Okay. Agenda item number 3, draft minutes for the Ethics Commission's October 18th, 2019 regular meeting.
I'll move the approval of the minutes.
I'll second. Public comment on this item? Okay, no public comment. All in favor of approving the minutes? Aye. So the minutes are unanimously approved. Agenda item number 4 is a show cause hearing in the matter of Ray Hartz versus President Norman Yee, Sunshine Ordinance Task Force file number 19042. So earlier this week, Mr. Hartz contacted commission staff to say that he had a family emergency and was unable to participate in today's meeting, and had asked that we continue it. So I will move to continue this matter, this show cause hearing, to the next regularly scheduled meeting of the commission, which will be on December 20th. The motion seconded. I'll call for public comment on this item. Agenda number 4, no public comment. All in favor?
Aye.
Aye. The motion to continue the show cause hearing in the matter of Ray Hartz versus President Norman Yee is continued to the December 20th meeting. Agenda item number 5, staff informational presentation on the Commission's jurisdiction over whistleblower retaliation protection.
Good afternoon, Commissioners. Thomas McLean, Senior Investigative Analyst here on staff. And I've prepared a presentation to correspond with the report that we submitted in the agenda for this meeting to go over our whistleblower retaliation jurisdiction. Presentation has two parts. I'm going to start with a brief overview of the law that we're charged with enforcing, and then move on to describe the process that enforcement staff typically goes through when we receive complaints alleging whistleblower retaliation. So the law. There are different local, state, and federal agencies who handle employment retaliation claims. And so for the purposes of any jurisdiction, there are three elements to a claim of employment retaliation. So a person, and this will be our complainant or the victim of the retaliation, they take an action or act in a way that is legally protected. They do something that they have a right to do. Second, so we call that engaging in protected activity. Second, the retaliator takes an action related to the employment status of that complainant. So the retaliator has to have some power over the privileges of or status of the complainant's employment. So this we call an adverse employment action. And then third, there has to be a causal connection between the complainants engaging in the protected activity and the respondents taking that adverse employment action against the complainant. And different jurisdictions under those different legal regimes will have different causation standards under this element. So bringing that here to San Francisco, under our whistleblower protection ordinance, the ordinance prohibits an employer from taking an adverse employment action against a city officer or employee, or an officer or employee of a city contractor that is substantially motivated by that officer or employees engaging in protected activity. I'll briefly run through each of the elements under the ordinance. So protected activity. Here in San Francisco, under the ordinance, what qualifies someone as a whistleblower is filing a particular type of complaint with a particular city agency. That complaint has to allege a certain type of allegation. And taken together, these types of allegations relate to the general function of city government. And the complaint has to be to a certain city agency. So this can be to the whistleblower program within the controller's office. It can be to the district attorney's office, the city attorney's office, us here at Ethics, or to the complainant's own department. Adverse employment action, element 2. Some of these are fairly straightforward. Someone is terminated, someone is suspended, or someone is demoted. And then there are situations that are a bit less straightforward. And this can include a transfer or a reassignment in duties. But the legal test is whether that employment action would dissuade a reasonable worker from whistleblowing or participating in a whistleblower investigation, or if that action would be likely to materially affect an employee's job performance or that employee's opportunity for advancement. Third, causation. Under the ordinance, commission staff has to show that the underlying protected activity is a substantial motivating factor, that the whistleblowing was a substantial motivating factor for the adverse employment action. So it doesn't have to be the only reason, but it has to be more than a remote or trivial reason for taking that action against the complainant. There will be situations where an officer or employee engages in protected conduct, but also isn't performing their job duties to the required standard or isn't conducting themselves in the workplace to the required standard. So this standard, this burden of proof, attempts to balance, on the one hand, the need for employees to receive adequate protections for reporting important and sensitive issues within the function of city government, with the need for the city to render necessary and business-justified employment decisions.
Mr. McLean, could we go back to the protected activity definition? Because I just wanted to clarify for my own sake, as well as for the participants here today in the room, as well as those who are watching at home, that on page 4 of agenda item number 5, under protected activity, filing or attempting to file a complaint, that the Commission's jurisdiction for whistleblower complaints cover the protected activity that is enumerated here. It's not any complaint of activity that we have jurisdiction over, but what the complainant has to allege is improper government activity, such as misusing city funds or deficiencies in the quality of services, wasteful and inefficient government practices, or unlawful activity. So we don't necessarily have jurisdiction over everything that a whistleblower could complain about, is what I'm trying to say. Is that correct?
Yes, that is, Commissioner.
So, for example, like sexual harassment would not fall within our jurisdiction.
That is correct.
Thank you.
All right, part 2 of my presentation. I will go over some of the considerations that we take into account and just some of our day-to-day dealings with the ordinance and complaints. So the first question that we're going to ask is, has the complainant alleged protected activity for which the commission has jurisdiction? So when we're thinking about this big picture, that underlying protected activity is the X that marks the spot for who has jurisdiction. And for our purposes, we're looking at, did someone make the right type of complaint to one of the enumerated city agencies? Now, just because we might not be the right shop for this type of complaint doesn't mean that a city officer or a city employee isn't going to go without legal recourse or remedy. Because there are different local, state, and federal agencies that have jurisdiction over different types of that underlying protected activity. And when we, on staff, determine that a complainant or that a different agency may have jurisdiction over a complainant's type of underlying protected activity, then we will try to point the complainant in the right direction. So, for example, the Equal Employment Opportunity Division of San Francisco's Department of Human Resources. So this department has jurisdiction over retaliation based on city and county employees reporting discrimination or participating in investigations related to discrimination within city departments. The Public Employment Relations Board is a state agency that has jurisdiction over retaliation based on city and county employees here, or or employees of other localities, or at the state level, who exercise their rights to participate in labor union activities or collective bargaining activities.
Pardon me, if an employee comes forward and files a complaint with the Ethics Commission alleging retaliation based on those enumerated protected activities that relate to discrimination, since we don't have jurisdiction over it and there is a time limit for the employee to be able to file a claim alleging a whistleblower claim, how does that initial kind of first stop at the Ethics Commission and we redirect them, does that impact their statute of limitations in terms of their ability to, excuse me, pursue a claim? So if it takes 6 months for them to figure out, oh, I want to file a whistleblower claim, but I went to the or it takes almost 2 years to figure out I want to file a claim, and they come to the Ethics Commission. The 2 years has expired, but it was the wrong agency. What happens to their claim if it's not a complaint over which the commission has jurisdiction?
So I can't speak to the statute of limitations for other agencies and whether they have tolling regimes or not to extend those statute of limitations. But upon intake of a complaint, staff will endeavor to figure out that first question, is this the right place for it, and try to quickly let a complainant know that this may not be the appropriate place for it, and where that appropriate place could be.
Thank you.
Maybe just one point of clarification is that in distinction to most other complaints that the Enforcement Division receives, it's much more typical for us to receive retaliation complaints over the phone. And so we have immediate contact with the complainant. We hear a reasonably full rehearsal of the facts. And so we can make those jurisdictional determinations pretty quickly at the outset, usually while the complainant is on the phone or very soon thereafter, in distinction, say, to some of the complaints that come to us in writing, which sort of stand in line for the commission staff's ability to conduct preliminary review. So that's to say that there is typically a much quicker turnaround in verifying that the commission might have jurisdiction over a retaliation sort of complaint, going to Chair Chu's concern about the complainant's deadlines with other agencies.
Right, that actually was, when we got to that, I don't know if I could have asked that question here, but in the enforcement report, we do have the monthly report on the time it takes to handle preliminary review matters, and that if it's in months, then if that eats up the time frame. So thank you, that's very helpful to clarify that most of the complaints can be dealt with over the phone.
All right, I'll move on to the second part of our analysis. So did the complainant suffer an adverse employment action? As I touched on a bit above, sometimes the analysis is fairly straightforward. Someone is either fired or they're not. Someone is either demoted or they're not. But then there are situations that are a little less clear. And require a deeper factual analysis. So in situations of maybe a transfer without a change in job classification, or maybe even a little more subtle. So a reassignment of duties, but again, within that given job classification. So in these types of situations, we're going to combine a deeper factual analysis and compare those facts that we gather to the relevant legal standards. So would that employment action dissuade a reasonable employee from blowing the whistle? And then would that change in their job status or the privileges of their employment materially affect the employee's job performance or that employee's opportunity for advancement?
Mr. McLean, I have a question regarding the investigation piece. So if the Department of Human Resources is also conducting its own investigation into the employment action that was taken or not taken with regard to a complainant, how does the Ethics Commission coordinate with or work in conjunction or the intersection of our investigation as well as an HR investigation? How does that play out? Or perhaps Mr. Pierce can speak to that.
I'll defer to Director of Enforcement.
Dr. Churchu, is the question what happens when two agencies have simultaneous jurisdiction?
Yes, and how do we partner with or coordinate with or do we interview witnesses like twice over? Do we look at an HR report? Like how does that all play out? And I'm sure it's very fact specific, but in general terms, if you could describe to us how the interplay is between the two agencies, that would be very helpful. And also, given that it could be a very sensitive and important topic for that individual in question. And do we always conduct our own investigation? Do we just base our findings ever only on the HR investigation? It would give us a sense would be very helpful.
In practice, I would say that it's pretty uncommon for a complaint of retaliation to belong both to the Ethics Commission and to another city agency. So it's most often the case that there is some underlying complaint that some other agency will have investigated. That's the first element, the protected activity, whether the city attorney's office or the whistleblower program or the complainant's own department has conducted an investigation into the underlying complaint, the whistleblowing itself. It may sometimes happen that there could be a complaint of retaliation that would lie with two jurisdictions. So as an example, it may be that a complainant faces retaliation based not only on whistleblowing, but also on an underlying complaint of discrimination. So it could be that the Department of Human Resources EEO division is looking at a retaliation angle based on underlying discrimination, and we are simultaneously looking at retaliation based on underlying whistleblowing. But that happens very rarely. And we do have a reasonably well-established relationship with DHR's EEO division and their director over there, Linda Simon. We are on the phone from time to time to verify which agency should assert jurisdiction over a complaint. And if it did happen that we decide that both agencies have simultaneous jurisdiction, I anticipate that we would just coordinate that investigation and conduct it simultaneously. But in the time that I've been here, that has yet to happen.
Okay, thank you.
Madam Chair,
Commissioner Lee.
can I ask a follow-up question regarding specifically the reassignment aspect? What happens if under the general job description, the supervisor can reassign an employee, whether a change of schedule or change of location work? How do you investigate if someone comes in and say, because I filed a whistleblower complaint and I got reassigned to a less desirable assignment or a schedule? So do you conduct due diligence to investigate that, or do you just say, well, that's part of part of your job description. So how far do you go when someone comes in and say, yes, it is within the purview of my, my job description that I can be reassigned, but I am reassigned to a very undesirable position, and I think is it as a result of my filing a complaint. Does that happen?
Any claim of whistleblower retaliation is going to include a lot of moving parts, and so sometimes some of the moving parts may be strong enough on their own to look like an employer retaliated against an employee, but then oftentimes each part standing alone may not look like all that much when taken in isolation. So I think it's looking at really the totality of the circumstances, doing a deep factual analysis and digging to try and figure out whether there's something there or whether not.
So the bottom line is the staff would not dismiss it outright and say, well, that's part of the supervisor's right. You will look into every allegation. That's the bottom line.
I'm happy to get Director of Enforcement's take on it, but that could very well be a situation where even though it is within the job duty of that employee, maybe the employee's been there 20 years, and so for 19 and a half years, they've been at a given yard, but then all of a sudden, that employee engages in protected conduct that the supervisor found out about, and even though we go back 20 years to that original job description, and different work locations could be part of that job description, but why after 19 years and 6 months is that employee being moved to a less desirable location? Now, if there are no other or no good other business justified reasons for that, so it depends. Thank you. So the third part of staff's analysis is going to be, can we show that the protected activity substantially motivated the adverse employment action? And this is the portion of the analysis of that complaint where we invest most of our investigative resources. Probably nobody is going to confess to retaliating against someone who they supervise. And this is a situation where we're trying to figure out motivation. So we have to get into someone's mind and figure out why they did what they did. And almost nowhere else in our jurisdiction over campaign finance, lobbying, or government ethics do we have to figure out someone's motivation. This is a specific intent charge, and so we ask ourselves certain questions to try and generate circumstantial evidence to show what motivated that given action. Did the retaliator have knowledge or suspect the protected activity by this complainant? You can't be substantially motivated by something that you don't know about. But even if a complainant, say, files an anonymous complaint with a different department, and that department comes to complainant's department and investigates, even again, complainant is anonymous, but they interview supervisor, and that complaint is regarding a certain set of facts that only complainant could know, then that could give that supervisor pretty good reason to suspect that complainant may have been the one to blow the whistle. Now, on the flip side of that knowledge, did the department who say came in to investigate the whistleblowing claim, did they only begin their investigation after the adverse employment action? Where the adverse employment action has to be substantially motivated by the protected activity, but if supervisor only found out about the protected activity after the adverse employment action had been taken, that adverse employment action couldn't have been motivated by the protected activity. We ask and look at what is the timing of the protected activity in relation to the adverse employment action? Are they close to each other in time, which can tend to show that it may have been motivated by the protected activity? Was it a week apart? But again, in contrast, was it 2 years apart? So looking at the timing between those two events, or in terms of timing, did the employment action come before the protected activity? Because again, it has to substantially motivate. So one of those has to naturally be before the other. We look at and inquire into the relationship between the retaliator and the complainant. If, for example, the alleged adverse employment action is a negative performance review, well, was this part of possibly a downward trend in performance by that employee? Did supervisor warn employee in years prior that they needed to improve their performance? Or had they been on an upward trend? And would a lower performance review be unusual in the circumstances? Is complainant, after engaging in the protected activity, treated differently than other employees in the unit or in a given department? So looking into that relationship between the alleged retaliator and the complainant. How do we go about answering these questions? So we review, request and review documentary evidence. Performance reviews will go through personnel files, and not just of, for example, the complainant, but we'll see, the supervisor give everyone a certain type of review that year, or does the supervisor treat everyone in a similar fashion? Correspondence between a complainant and the respondent to try and get into that relationship. And then primarily, these cases are matters where we have to go out and interview people, because every workplace, because of the different people and personalities that they are made up of, is its own little world. And at the outset, and before doing these interviews, we're going to ask the complainant, who should we talk to? Who is familiar with your supervisor? Who's familiar with your relationship with your supervisor? Who's familiar with your work product? who can kind of give us that baseline that we can look to see if this was adverse employment action and if it may have been substantially motivated by engaging in protected activity. In a particular case, we interviewed 8 city employees to investigate a claim of whistleblower retaliation. Including complainant at the outset to say, who should we talk to? And then ultimately we interviewed coworkers of the employee in that employee's unit, and we interviewed the employee's prior supervisor to the alleged retaliator. We interviewed the employee's supervisor subsequent to the alleged retaliator, to really try and dig into the day-to-day reality of that given unit and figure out whether protected activity substantially motivated the adverse employment action. So ultimately, we do all this digging and try and get all these facts in these highly factual analyses and try to answer the questions that I posed earlier to figure out whether something stands out and looks like it was and that something being protected activity, whether that stands out as substantially motivating an adverse employment action. I'm happy to take any questions.
Commissioner Smith?
There are a lot of subjective decisions in this analysis, more so than one gets in a lot of areas. Was it an adverse? Was there an adverse impact? Was it retaliation? Anyway, there's several of them. What protection or what appellate process of standard of review does the complainant have if the decision goes against him or her? Is there one, and if so, who handles that?
There is, and I'll defer to Director of
Okay.
Enforcement.
So a complainant in the retaliation context has for their effectively appellate recourse what any complainant does, which would require them to file a writ against the city. And I suppose in this case, the complainant would potentially writ the Ethics Commission to try to get a superior court to say that the Ethics Commission failed to undertake a mandatory duty. I think that would be a pretty high burden for the plaintiff to meet. Effectively, the duty that the Ethics Commission has is to look at the complaint, investigate the complaint, make determinations, and the Ethics Commission does that in every instance. I don't know that a superior court could determine for itself that the Ethics Commission drew the wrong conclusion in a particular instance. My guess is that if a complainant were to go to all that trouble, they would be better off suing the employer as opposed to suing the Ethics Commission and trying to show that the employment decision was based on some improper consideration. And complainants can do that in a number of ways. They do it, for example, by filing a grievance and pursuing the grievance process pursuant to their collective bargaining agreements. They could, in theory, file against the city and county a claim under Section 1983 if they could show that some protected right of theirs had been violated. So the short answer to your question is that there is not an obvious appeals process.
Okay, thank you.
Commissioner, yes, of course. Commissioner Rose.
I don't recall in my tenure here one of these coming to the commission, so I'm just curious procedurally, and given the necessity of maintaining the anonymity of the whistleblower, how these are actually handled. If you were to have a hypothetical retaliation claim and find that in fact there was retaliation against the whistleblower, would you make a recommendation to the commission and we would have a public agenda item on that? Or is this something that is the executive director's discretion to determine?
If we were to move forward with a finding of probable cause, so remembering under the enforcement regulations that the administrative process immediately after the investigation permits staff to recommend that the commission find probable cause, staff could issue a confidential determination of probable cause that goes before the executive director. The respondent has the option to file a response. We can then rebut the response, but the executive director would make her recommendation on probable cause, which then comes, again, confidentially before the commission for your ratification. If you were to ratify, if you were to find, yeah, there is probable cause in this particular instance, the regulations do not distinguish between administrative hearings against retaliation respondents and respondents under the other 3 articles of the Campaign and Governmental Conduct Code. So you're right, that would be a public hearing.
Okay.
And the I think what happens is that when a whistleblower comes forward with a claim of retaliation, they know a couple of things. One is that it's highly likely that in the course of staff's investigation, their employer will know that they have filed a complaint of retaliation, because we have to conduct these interviews. And we're very honest and open with complainants about that fact. The other is that if it does go to a hearing, the public too will know that they had been a whistleblower. But my suspicion is that when complainants believe that they have faced retaliation, they may not mind that information becomes public, because they are aggrieved by the misconduct against them.
All right. No, thank you. I didn't realize that this enforcement proceeding fell within the same envelope as the other enforcement. So that explains it. I can see how it would be a very careful approach, because you also have very strict rules about not exposing the identity of the whistleblower, and there's penalties for that. And then my last question is from a remedy point of view. If there were to be a finding of improper retaliation against an employee, what is the remedy available to the complainant? Is that something that the Ethics Commission then decides, or is that prescribed by the ordinance?
The ordinance provides that the Ethics Commission can assess a monetary penalty against the respondent up to $5,000. My belief is that more often than not, the respondent would pay that penalty out of pocket, that would probably accrue as personal liability, but it's possible that a respondent could successfully show that they took the action in the ordinary course of business. I'm not sure, but I have been told that there may be situations in which the city and county would pay the penalty, but that would be worked out based on the facts of the particular case. The ordinance also provides that the Ethics Commission can recommend that the department restore the complainant to the status quo, to the position they occupied before they faced the adverse employment action, subject to the civil service rules and other procedural considerations, but the commission itself cannot take an action to undo the adverse employment action. You can only recommend.
All right. Thank you. I appreciate that.
Commissioner Lee?
Madam Chair, I'm interested in knowing how the employees will know about this program and the protection. So how is the information conveyed to them? And what role, since the commission is, in the front line, so to speak, would you be, or have you been working with whether the employees groups or what have you to let them know about, how they can work with the commission to come forward if they need to or want to?
The whistleblower program publishes materials that alert potential whistleblowers that their whistleblowing will be a protected activity, and those materials direct complainants to contact the Ethics Commission if they believe that they have been the victim of retaliation. I'm aware that many of those complainants will call the whistleblower program directly when they believe that they have faced retaliation, and at that point, the whistleblower program will direct them to reach out to us instead. It's also the case that amendments to the Whistleblower Protection Ordinance that were adopted and became effective, I believe, in January of this year, require that the city renew its training and promotional materials. So our office has been collaborating with the whistleblower program in the controller's office, as well as the Department of Human Resources, to update those materials. We have produced nearly complete drafts of new posters that will alert employees about the protections available to them should they blow the whistle. We have updated the new employee training. There's a video that new employees to the city and county receive, which also alerts them both to the opportunity to blow the whistle and the protections that would be available to them if they do. And then finally, the amendments to the Whistleblower Protection Ordinance now impose affirmative obligations on supervisors within the city and county. And those obligations include to assist an employee if they approach them. If an employee approaches a supervisor, any supervisor, and says, I believe that I am being retaliated against, the ordinance now requires supervisors to assist that employee by referring them to us, the Ethics Commission, by documenting and writing the date and time of that referral, and by keeping confidential the fact that the employee has alleged retaliation. And we, again, in coordination with DHR and the Controller's Office, have produced both written materials and an online training that supervisors will be required to review on an annual basis so that they know that those protections exist and that they face affirmative obligations. And the ordinance endeavors to make those obligations meaningful by exposing supervisors to potential liability if they fail to fulfill those obligations. So a supervisor could face the same penalties as someone who actually retaliates against the employee should the supervisor fail properly to assist a retaliation complainant.
A couple more
Yes.
minor questions. When you mentioned the covered groups, I think in the written materials, the city subcontractors were also included, right? So just
Yes,
clarify
Commissioner.
that. Okay. The second thing is, in terms of confidentiality and privacy, will that be part of the employee's permanent personnel record that he or she had filed a whistleblower complaint? So in case that person is going to be applying for future jobs within the city, is that part of that person's personnel record?
No, Commissioner.
Okay. That's it. Thank you.
Thank you. Any other questions? Call for a public comment on agenda item number 5. Thank you, Mr. McLean. That was very, very helpful.
Thank you.
Good afternoon, Commissioners and Director Pelham. I'm Dr. Derek Kerr, a whistleblower. You've heard a thorough yet theoretical description of the so-called whistleblower protections. But there's a gaping omission. Nothing about the effectiveness of the Ethics Commission in protecting whistleblowers against retaliation. In fact, ethics has never sustained a single retaliation complaint since it began reviewing them in 1995. 0 retaliation claims sustained over 25 years, and you've reviewed over 100. ethics makes it appear that retaliation is non-existent and that whistleblowers are deluded. Yet in some cases, like mine, whistleblowers obtained validation and compensation in court after being dismissed by ethics. Savvy whistleblowers, mostly lawyers, bypass ethics entirely and take their retaliation claims straight to court and the media. They know it's a dead end. In my experience, there are several reasons why ethics has never recognized retaliation. First, ethics investigations are superficial and ineffective. They don't use subpoenas, depositions, or discovery to gather evidence. Partly, that's due to inadequate resources. Second, investigations are tainted by the staff's greater empathy for their siblings within the city family, those who are being accused of retaliation. Third, the staff collaborate with and are influenced by city attorneys who defend the very officials we accuse of retaliation. Fourth, investigations are compromised by fears of retaliatory budget and staffing cuts by City Hall. Ethics is utterly dependent upon the folks it supposedly keeps in check. If staff did sustain a retaliation case, they would be treated just like whistleblowers. You could get a handle on this failure to protect by asking for an audit that answers 3 questions. 1, exactly why have no whistleblower retaliation cases ever been sustained by ethics? Why? Number 2, why do retaliation claims dismissed by ethics find vindication in court? And 3, why do some whistleblower retaliation claims bypass ethics altogether? Please check. Thank you very much.
Thank you.
I second my colleague, DPH employee. 2010 to 2015, FBI investigate many management staff and staff in San Francisco County government for bribery, extortion, and many other illegal stuff, including human trafficking. Years later, many of the employees retaliate. April 2017 to July 2017, I brought 5 government employees to ethics commissions, filed with audio tape and reports. Months later, I've never get back by anyone except someone told me everything that we gave it to them and reported to them was missing. Ethics Commission is the most unethical department in San Francisco. 2014 to 2015, I was a civic grand jury. I was one of the authors stringing the whistleblower to protect their job and protect their family. Yet, Ethics Commission colluded with Department of Human Resources, EEOC, and other department heads continue to make circles that is violate all the people who stood up, report through whistleblowers. As you can hear, many of the people coming in here to you ethics commissions, 2 of you are new, but many of your ex-ethics commissioners left the chamber. I assume that you guys have a legal background, attorney or law, some kind of legal background. The Ethics Commission staff work together with many of the department heads, purposely get the information from the employees who has been retaliated and destroy the evidence. I gave you 5 employees. I was one of the 6, because I was the 6th person, did a lot of investigation and support the people who has been retaliated. This ordinance, whistleblower is part of the government entity that is supported by the liberals and the Democrats and the people who will violate the people, the law that is created by the people. I'm sorry to say that the Ethics Commission's right here, the staff in front of me, I personally do not have trust with you. It's because for everything that I reported to you, none of the complaint that I brought to you has been addressed. Square and fair. Shame on you people sitting in here collecting your paycheck. Thank you, commissioners.
Thank you. Other public comment?
Madam Chair?
Yes.
As I recall, when Ms. Zhao's allegations were brought up, I think the staff has provided I don't think it was a memo, but it was a letter to the commission that was open to the public. So may I request, if that was still my recollection, that we include that in today's deliberation?
I don't know if it was public, but I suppose it's public.
If you can check.
Staff have communicated with the commission about the status of Ms. Zhao's concerns over the course of the many months in which she has brought those concerns before the commission. Those communications have not been attached to any agenda items in the past, but Deputy City Attorney Shen looks to be expressing some concern, but effectively staff have sought to work with Ms. Zhao to resolve her concerns and have, in our belief, have not received adequate follow-up from her end. But I'm happy to provide additional clarification.
Commissioner Lee?
I remember one of the former commissioners had read into the record a certain aspect of the staff's research.
Commissioner, I know that in previous discussions, when the same question has been raised by the public speaker, there was some comment from one of the commissioners. I'm happy to go back and check those records to see what information that was that commissioner was operating from. Certainly, if there's communication that we provided to this commission, we will provide it to you as well. So let us do a little bit of research and get back to you with anything that is available on that.
Thank you.
Thank you. Vice Chair Ambrose.
Regarding the other public commenter, Dr. Kerr, I think you raise an interesting question. I'm not sure how one would actually go about an audit, and that's not what I'm asking for. But apropos the question from the other commissioner about the judicial review of our decisions, I think it would be useful for the staff to understand what decisions were made, presumably by staff that preceded you, because I know you haven't all been here that very long, and whether or not those decisions were overturned or rejected or set aside by judicial review, and on what basis. So I'm not asking for a formal report, but I'm recommending that you look into that. And if you're not familiar with any court decisions, finding retaliation where the city had previously found none, maybe the city attorney's office can identify some in the last few years. I just think we can always get better at what we do with respect to investigations, and if there were failings because it was upheld in court but not administratively, then we should learn from that process. And I thank you for your public comments.
Thank you. Any other public comment on this item? Okay, agenda item number 6, discussion of monthly staff policy report. Excuse me.
Thank you, Chair Chu and Commissioners. I'm Pat Ford, Senior Policy and Legislative Affairs Counsel. I have a few updates before you under Agenda Item 6 on ongoing policy projects and other projects that I'm working on that aren't strictly policy items. The first one that you see here is the electronic filing of the Form 700. And this project is one that we've been working on for a while. You've heard a few updates about it. This is to have all filers in the city who file the Form 700 Statement of Economic Interests do so electronically. Right now, most filers file on paper with their departments. This project seeks to have all filers file electronically through NetFile starting in 2021. The big update for you this month is that we met with 5 representatives from employee bargaining units, and I would say that the meeting was very successful. We had a very constructive dialogue with the union representatives. They really engaged with us. They asked a lot of very helpful questions that helped guide our thinking on what would be helpful to filers. They were especially interested in the kind of trainings that our office would be providing, both on the e-filing system itself, but also just on Form 700 filing generally. What kind of information do filers put on the form? What's best practices for filing this form? So it seems like there's a lot of outreach that we can continue to do and include the union representatives more so than we have in the past. It seems that they want to be included in our outreach and our trainings. So that's definitely something that we're going to do. That seems like it would be helpful to employees, that they would look to their unions as a source of information and guidance. So anytime we can find a channel to do that, we'll definitely make full use of it. So I think that was a very helpful takeaway for us from that meeting. And in terms of the outcome, there may be information requests that the unions ask for. They may ask for lists of filers or other information. It's not clear at this time, but for all intents and purposes, it appears that this was the first and last meeting that we will be having with the unions. They were fully supportive of the project. They said it seemed like a good idea, that they think e-filing will be a big step up from paper filing, and that they were persuaded that this would actually be helpful both for the filers as well as for the public, which is what we were trying to communicate to them, and we firmly believe that's true of the project. So we left the room basically in agreement that the project was a good idea, and that they didn't see any major issues, assuming that we could provide training to the level that they were asking for, and we're confident that we can. So at this point, DHR has sent a follow-up email to the union reps who were there, thanking them for their participation and letting them know that at this point we are going to move forward with the project. So right now it appears that meet and confer is essentially finished on this, and at this point we're going to move ahead full steam on the project, and I will be bringing a set of regulations before you most likely at the January meeting. I think I'd like a little bit more time to really get these fleshed out and get them very watertight. So I think December might be a little bit of a quick turn, but January would still give us plenty of time to do what we need to do to meet that Jan 1, 2021 goal.
That's fantastic. Congratulations. That's wonderful news that the meet and confer went so smoothly and expeditiously, and there was a great meeting of the minds, and we can move full steam ahead. So please do keep us updated on the rollout, and we look forward to the regs. And also, if you could brief us on the training materials, and and consider also whether or not those materials would be useful for the broader population as well as a refresh, as this is an annual effort that everyone has to undertake.
Yep, absolutely, will do. Another thing that we discussed at the meeting, which is a good segue into another project I want to update you on, we talked about the biennial code review, which is something that happens every other year in even-numbered years. And I think I've talked about this before you in previous meetings, but essentially this is the process in which the city goes back and looks at the conflict of interest code and the lists of employees who are required to file, and essentially just reviews it and updates it so that it reflects the current state of those lists. So if positions are added or discontinued, or if someone's job duties change, that list would be updated to reflect changes that have happened over the last 2 years. I think what the unions would find helpful and what we are more than willing to support them in is to do a little bit more of a rigorous review this coming year. So not just update for changes in job duties or adding or taking away positions, but to also help departments maybe take a little bit more thorough look at those lists. We heard the union reps express concern about some filers being included on the list that maybe shouldn't be, in their opinion, or filers that are required to file at a higher disclosure category, meaning disclosing more personal interests than their union representatives believe they should. So that's not necessarily something that would get caught up just if the departments were updating the list for new or changed positions, but they would really need to go back and review their prior determinations. So I think in order to facilitate that happening, meaning facilitate the unions giving that feedback to the departments, we may explore next year doing the biennial code review in a little bit different way. This is a process that ethics does not manage and are not solely in charge of, so it will involve some coordination with both the city attorney's office and the clerk of the board. So I can tell you that at this point, we're in the early stages of beginning those conversations, talking about how we're going to potentially move up the timelines, maybe try to involve the union representatives at an earlier stage in the process so that their feedback can be heard before the changes are kind of drafted, that they could be expressing their concerns to the departments at the time that the departments are thinking about the changes. That was something that was important to them at the meeting, so I think we're going to do our best to try and accommodate that.
But the Form 700 electronic filing project, it will proceed in parallel, and the two are not dependent on each other.
Correct. Those are two completely independent projects, two completely independent pieces of legislation, too. The biennial code review will be an ordinance, and the e-filing for all will be a regulation. And those will proceed completely independently. But it was important to the unions at this just past meeting that we did explore maybe a different way to do the biennial code review, or to involve them in it, I should say. So yes, those will be separate, but kind of related and relevant to each other. I think the unions see the biennial code review as maybe more important this coming year, with it in mind that the filing method will be different. So that's where we are. So good updates, good progress on that. Another set of regulations that I will be bringing before you soon are a narrow set of regulations to implement the second public financing ordinance that will be going into effect the first of this coming year. And these will be basically just updates to the regs so that they match changes in the code. So anywhere in the regulations that discuss the matching rate of 2 to 1, or the previous maximum amounts of funding that candidates could receive, or the previous starting point for spending limits, those all need to be updated since those figures were all changed. So I envision these regulation amendments being pretty brief, basically confined to just updating where necessary, not really doing anything beyond the scope of that ordinance. But I just wanted to make you aware of it, that that's something that we'll need to do, and hopefully I'll have that before you at your next meeting.
Okay. And would your hope be for us to approve those at the December meeting, or to consider and then take action in January?
I will certainly publicly notice them, so that you could take action on them. Okay. But obviously you can take as long as you need. If you would like to hear public comment, and you may have feedback or amendments that aren't appropriate to make during the meeting, I can absolutely bring them back at a subsequent meeting, but they will be ready if you would like to approve them.
Okay, and then from a timing standpoint, the ordinance goes into effect on January 1st?
Correct.
Of 2020, and then what is the timing for regs to become effective as well? Because once we approve, there's a they go over to the Board of Supervisors, and then there's a waiting period thereafter. So what does that timeline look like?
It's 60 days from the time that we transmit the approved regulations to the board that they become operative, assuming that the board does not veto them, which has not happened in the recent past. So typically it means that there's a 60-day waiting period. So there would be a period of time during which the new ordinance will be operative, but the new regs will not be. So there will be a period of time when the regs don't match the code. I don't think that it will be a serious problem. I mean, there are numbers that don't match. I think we can advise people that the principles contained in the regs are still the case, even if the numbers aren't syncing up. But definitely want to fix that as soon as we can.
Thank you.
Then separately, another set of regulations that I'll bring before you, kind of in the same vein, will be regulations to update because of changes from Proposition F. So as you know, Proposition F was a ballot measure that appeared on the November ballot, and it was approved. So there will be amendments to the Campaign and Governmental Conduct Code that will go into effect 10 days after the election results are certified. So that should be sometime in early December. So similar to the public financing ordinance, since there are changes to the code, we need to go into the regs, update the regs to match the code. So
If I may.
Yeah, Commissioner Ambrose.
Regarding Proposition F, we know what it read and that it passed, but because it wasn't heard here at the commission, because it went directly to the ballot and we weren't able to comment on it directly, I think it would be useful to the viewing public and people attend the meeting if you can just plan on briefly reviewing the provisions of Proposition F in the context of the implementing regulations that you're going to be recommending. I think that would be helpful. So, and it will, like, as you said, the vote will be certified by then, so it will be enforced. So when you're putting out the materials, thank you.
Yep, I could definitely do that. I think that would be good context for the reg amendments to see what changes of the code these are based
Yeah,
on.
no, they're fairly significant changes. I think we need to get the word out there, so.
Yep, absolutely.
And also, Mr. Ford, if you could include, sort of what some of the opportunities and challenges are, as part of that implementation as well. And I think this may bleed into the executive director report, since this is not funded and we don't currently have it in our budget. What would the impact be to be able to implement these in a timely and effective fashion?
I have one more follow-up. So the regulations that you'd be proposing in December for Proposition F, those also have a 60-day, is that, okay.
Correct.
Right.
And I think for the sake of efficiency in the meeting, I may combine those two sets of regulations into one agenda item, if that's not too bizarre.
No, fine.
No, that's fine.
Okay. I think that might be a little bit more efficient than having them be two separate items, because they are at least kind of in the same realm of updating regulations to match recent legislation, even if they're not conceptually on the same topics.
And then related, but not necessarily the same, would be the communication and outreach portion. Going back to some of the themes of this meeting and also continuing throughout, is how do we make sure that people who are affected by these regulations know what their obligations are, who should, and when they need to comply, and what they need to do to comply. So updating us or giving an overview of what that engagement and compliance rollout plan might look like would be very helpful as well.
Sure. Yeah, I think we could definitely invite Gayatri Tekondil to present on that along with the regs.
Thank you.
Great, thanks.
So the last two items that I wanted to briefly mention are that in January, I hope to bring the policy prioritization plan before you again for the periodic update. As we've just been talking about, a number of projects are kind of in their final stages. The e-filing for all, at least my involvement in that project, is reaching its end now that the meet and confer process is essentially finished and the regs will be before you shortly. That will free me up to work on some other matters. Likewise, with the public financing review project, this set of regulation amendments will be kind of the last step in that project being completed, at least my primary involvement in it. So I think that it would be an appropriate time to bring the policy prioritization plan before you and start looking forward to potentially what could be projects in the near term, first half of calendar year 2020, for policy to work on. One that I definitely will be working on that you'll see on that plan will be the biennial code review. That's something that will definitely be occupying some of my time. Similar to the e-filing for all, I'll be engaged with the Department of Human Resources to work with the employee bargaining units to discuss what I was mentioning earlier, their concerns about the filer lists and how to get them involved in that process. And I suspect that will most likely be a little bit longer of a meet and confer process, could involve multiple meetings, potentially more union reps. I can say from experience, last year there were more union representatives involved in that meet and confer than there were for the e-filing meet and confer. So that's something that will be occupying my time. But I think there could be one additional policy project that I could work on in tandem with that one. So I'm hoping in January to help facilitate your discussion of that.
We look forward to that. Thank you.
The last item to mention is that staff is heading to Kogel soon, and I'm sure Director Pelham will update you on that. But I've been working on a few things to get ready for Kogel. I'll be a panelist, so I've been working with the moderator and my fellow panelists to talk about what material we're going to present on and getting that material ready. Also been helping other panelists as they research other agencies' practices to discuss during their panels, being a resource to them. So Gayatri and I had a phone call yesterday with senior counsel at the FPPC talking about our opinion and advice regulations, how we developed those and how we've been implementing them, and how that's been an improvement for our processes. That's something that they may discuss at Kogel this year. So it was nice to be able to share that ahead of the conference. And then there are also a number of publications that various folks prepare for Kogel. They're kind of like a survey. So they'll do a survey for updates in campaign finance or updates in ethics laws. So I submitted an entry about the public financing project, about the legislative updates that the commission has done to that program. So hopefully that'll be something that's included in that publication. So people nationwide working in government ethics and campaign finance will be made aware of that project. And then next week I'll be doing one for ethics. So I'll be looking at new ethics laws that are in San Francisco. So we have a few of those. So hopefully we'll be able to put together some information to keep everyone abreast of what we're working on here, which is always important to have the network of other ethics professionals. We know what they're doing. They know what we're doing. As you know, that's always a part of our policy projects is the jurisdictional approach, looking at what our colleagues are doing, learning from their experiences, and a lot of that groundwork gets done at Kogel, frankly. So it's definitely a privilege to be able to do that. I think that's the end of my updates. I'd be glad to answer any questions that you have.
Well, I think that the power and the impact of these opportunities for professionals to get together to network and share best practices and learn from each other is really valuable. And so I hope that you get a lot out of it. I think that you do every year. And congratulations in advance on the panel and the work that and the publication, which, knock on wood, will be chosen. But I think that we have made progress, in public finance, certainly, and in other areas in San Francisco. And so please carry the flag forward over to Kogel, and would look forward to your report out on what the conference, what you got out of the conference, whatever in the team gets out of the conference, and what you learned, and new ideas to bring forward. And hopefully that can shape part of our policy prioritization discussion in January as well.
Yes, we always come back with lots of ideas. So.
Fantastic. Any other questions or comments from commissioners? All right. Public comment on this agenda item? No public comment, okay. Agenda item number 7, discussion of monthly staff enforcement report, including an informational presentation. No, we did that already, on the city's whistleblower protection ordinance, and an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting.
Chair, thank you for the, I'm going to turn this over to Jeff Pierce, but our apologies, we did leave a reference to Mr. McLean's report
Yes.
in this, so, but that, there is no further report on that in this
Okay.
item, and it was strictly the report that Mr. McLean gave earlier.
Okay, thank you for the clarification.
Thank you, Chair Chu and Commissioners and Director Pelham. So what we had hoped might be the main event for this agenda item this month was an appearance from the Director of the Bureau of Delinquent Revenue, Jeff Smeichel. He did come before the Commission, I think it was about 18 months ago, to address a number of similar questions that the Commission had at that time. We've clearly had some turnover in commissioners since then, and given the ongoing work between the Enforcement Division and the Bureau to collect those debts, it makes sense to bring somebody from the Bureau before you to answer the very specific questions that you have about the process that they undertake. Unfortunately, Director Smeichel had a scheduling conflict and was not able to join us. He should be able to join in December if we keep that meeting on the calendar, but he's aware that you have questions, and he looks forward to addressing those with you at the next opportunity.
Mr. Pierce, I would just like, for the record, for the two items on agenda item number 7, page 2, and the very bottom in the chart, the first two items, Chris Jackson, I think that this entry has been unchanged since I joined the commission. And so I would like to understand from the director of the Bureau of Delinquent Revenues, what are they doing and what will they do differently in order to lead to a different outcome? Since the original amount referred $6,601 and there's a balance of $5,100, I mean, hasn't moved in the last 3 years. So that would be what I would be interested in hearing.
I will communicate your questions to him. I would also note that the table this month is unupdated from what we put in front of you for the October meeting. I think because the November meeting falls closer to the beginning of the month, and because we had a holiday on Monday and had to get materials out sooner than we ordinarily do, the Bureau was unable to give us their monthly updates ahead of our ability to finalize this agenda item. But I can provide a couple of updates on that table from a communication that we received from them earlier this week. No changes to the Chris Jackson ones, but a couple of other things. One is that the Noe Valley Democratic Club, near the bottom there on page 3, has now paid in full the debt that they owed. You'll note from last month that they had promised to do so, and they have since done that. As to San Franciscans for Democracy, the Bureau has mailed to the debtor there a letter notifying them of the Bureau's intent to file a small claims lawsuit. So one update there. And then as to the SF Latino Democratic Club, we had some conversation about that during the October meeting. The Bureau is now working with their legal department to sort out what options they may have in the face of the supposed representative's non-responsiveness. The attorney who had indicated that he was representing that particular committee. So the Bureau is exploring with their in-house lawyers what their options might be. But turning back to the front of the report, as you know, we've had a series of ongoing conversations about improvements that the Enforcement Division is undertaking in the process that we apply in receiving and reviewing complaints, in evaluating which of those complaints we should convert into investigations, and then working through the matters that exist on the open investigations docket. That work so far has, again, just to reiterate, taken these two tracks. One is to develop this set of discretionary factors by which the staff can allocate limited enforcement resources toward the matters that we think might matter most to the commission and to the city and county, to the public. We have initiated conversations about what those factors mean and how to apply them both to matters that exist on the current open investigations docket, as well as new complaints that come through. So we are beginning to implement an understanding of what it means to exercise additional discretion toward the matters for which the commission may have jurisdiction. In addition, we are moving forward with the process to update the commission's fixed penalty policy. This was on guidance that commissioners provided in a prior meeting, advising staff that we should, in fact, move forward with that. You'll note that we have a couple of interested persons meetings scheduled for next week, one Wednesday evening and another toward the beginning at 1 o'clock next Friday. Both of those meetings will take place in the basement of the building in which the commission's offices sit. That's 25 Van Ness. We are mindful of Commissioner Lee's request that we host at least one interested person meeting in a I don't know, I'm not 100% sure if it's a non-city building, but in any event, not a building not the commission's offices. You'll remember that the process will include at least 2 rounds of interested persons meetings. These initial meetings are to gather the scope of considerations that the stakeholders believe the commission should undertake in revising the policy. So we have provided for potential participants a list of questions that we think are relevant to these initial meetings. That's to say that these first meetings will not be to respond to a proposed draft, but instead are just to seek sort of broader feedback about what this revision process could look like. We are also having meetings internally. Enforcement staff are consulting with staff of other divisions to get their input based on their experience administering their various programs to evaluate what other provisions of law might be governed by a fixed penalty policy. We are moving forward as well with consulting with peer jurisdictions, trying to evaluate beyond the Fair Political Practices Commission whether any of our peer agencies do in fact treat any of their enforcement matters in this streamlined fashion, or whether they apply a schedule of fixed penalties to any particular kinds of violations that they handle within those jurisdictions. And then the aim is to analyze all of that information that we have collected and bring to you, if not by the December meeting, then soon thereafter, a proposed revision for your initial feedback as a non-action item. And that initial proposal will be really just to solicit your feedback for the reasons that I stated, that we will have subsequent interested persons meetings to respond to that particular draft. So that process is underway. We welcome any commissioners to participate in those interested persons meetings if you're interested and able.
And so, Deputy City Attorney Shen, we would be limited to 2 commissioners participating in those interested persons meetings, right? Okay.
I'm happy to field any questions.
Any questions? No? Okay, great. Thank you. Public comment? No public comment. Agenda item number 8, discussion of Executive Director's report, an update of various programmatic and operational highlights of Ethics Commission staff activities since the Commission's last monthly meeting.
Thank you, Chair. I've asked our Deputy Director and Chief Programs Officer, Gayatri Taikadil, to join us in Jeff's spot because we have a number of items here and wanted to be able to answer any questions that you might have about various programs that are underway in our operational planning since my last report to you at the October meeting. As you'll see from the report, there are a number of areas where we have been continuing to to map out our operations for this year with the resources that we have. We've completed our goal-setting process within the staff and have, I think, a very clear sense of what the key priorities are that we're working on and how each of the different areas of our office are now working and supporting the same goals so that we can be as effective and efficient as possible with what we have in front of us for the fiscal year. It's quite a daunting task, as you know, from all of the reports you've been hearing from Pat Ford and Jeff Pierce and others. So a couple of highlights. We provided some information on the updated dashboards for you. I would just note for those watching or listening that the links to our dashboard are live in the document online. So we want to make it easy for people when they're reading about election information and campaign activity to be able to go directly to the information that provides more data that they might want to look at and explore and ask questions of with whatever they might have on their minds. So those links are provided live here. Stephen Massey and a broad effort throughout the office, engagement compliance, and our electronic and disclosure analysis team really worked quite diligently over the course of the election to make sure that we had information updated. Feedback was looped back into the process so that we could make sure that the data dashboards were as useful as possible. We did have direct feedback from users outside of the office that said, hey, I used to see something there, I don't see it there now. And we were trying to be as responsive as possible to make sure that we could get that information back up online so that it continues to be relevant and useful and timely for the public.
Director Pelham, I have a question for Mr. Ford. For the Campaigns Finance Dashboard website for the November 2019 election, will all of the finals, like the late filings that come in on the eve of the elections, will those all be posted and available now?
Yes, and those will continue to update. Those
Right.
dashboards will continue to update. So once the committees file their year-end 460s
Yeah.
in January, that
That
information will also go in. So
And is it real-time updating?
it's updated every day.
Every day, okay.
So it'll take all of the last 24 hours of
Oh.
information.
Fantastic.
And if I may ask a
Yes.
follow-up question, when it's finally updated, when you have the final report, do you usually issue like a, public notice or just a general press release so people will know about the final numbers?
No, I don't think we've typically done that. No.
I would request that we do that.
So the request is that when the 460s are due at the end of January,
Yeah,
that
the final
we-
ones.
Sorry?
When the final numbers are submitted.
Yeah, correct. That we issue a public notice just to let the public
Yeah.
know that that information is available. Yeah, I think
Or would you like to actually have the results with numbers, not just that the information is available? I mean, I think it would be very informative to say on Prop C, this is how much money was spent. The supervisor races, this is how much money was spent. Just statement of the fact.
Donors,
Right.
all the public information, because very few people would actually go into our website to review that. But if we were to issue a general press release, it would be picked up by concerned neighborhood groups and the general press. I think that would be much more informative to the.
To push the information as opposed to have it be available to be pulled.
Yeah, one thing that I realized I failed to mention earlier, which is relevant here, so I'll bring it up, is that we do a post-election report that we give to the mayor and the board of supervisors after every election, in which at least one candidate receives public financing. That report does go into the kind of end of election statistics about how much each candidate raised and spent, how much public financing they got. So it does that for candidates. That report does. It doesn't cover measures.
Only for publicly financed candidates or all candidates?
For publicly financed candidates
Public-
or races in which
Public financing
yeah.
was, okay.
exactly. Yeah, but it doesn't cover measures. That report.
I think it would be great if we could include that with the other initiatives.
Hello, Commissioners. I also wanted to add, we'll certainly consider the suggestion. I also wanted to add that during the election period, we make sure that our homepage highlights the campaign dashboards, so anybody visiting our website will be able to easily access them. I understand that we should probably do more of outreach and pushing the information out as well. But that information is easily available on our homepage as a major banner during the election cycle and after. Yeah.
Because I recognize that, this is a small but mighty team of ethics staff, but I think if we can start being more proactive with all the information that we have, that would be a great way of, increasing the public awareness of what we actually do and what. Thank you.
Yeah, I agree.
I think Pat Ford in his policy report touched on Proposition F, so I won't go into that further here, but we did start meetings with the last month to identify what implementation and information needs existed to implement that new ballot measure that was approved by voters on November the 5th. And a group from the office met yesterday with the planning department staff to identify what information and processes are in place over there so that we can make sure we're getting information directed appropriately to the experts on what those processes involve. So to your point, Vice Chair Ambrose, having that information to provide context for the public, we're in the process of pulling that together, so that should inform that report and that information that comes back to you all in the public at a near-term meeting. We also wanted to provide an update in this report about some of the work that's been done now that we have had a seat filled with a very talented person among the adding to the other talented folks in the office. John Kim has been working on the lobbying program, and we're very hopeful that there will be some spin-off reports that can probably come your way in the upcoming months, informational reports about what we're seeing in the lobbying program. But he has been really taking a deep dive into how that program is administered, where are some of the procedural gaps that we have been able to close in getting back to filers, in getting filings current, and really sort of dusting off that program. So there's been a lot of work to establish, consistent timeframes now that we have the resources dedicated to the program. And I think that's showing in numbers that we see in everything from late fees coming in to registration fees that are timely, as we'll see probably spike in February as is normally the case when people register at that time of the year. But just wanted to highlight that for you as well. There's been a lot of collaboration with not just internally with staff, but externally with filers and stakeholders about our lobbying online filing system. We know that there have been hiccups with that over time, and that we really now are looking at revising our system, working with our NetFile provider to strengthen that filing system. So that's also a piece of what John has been leading within the staff, working with our electronic data folks to identify where we can make improvements to really strengthen how that information is provided to the public and how filers experience submitting their information through that system for the public's disclosure purposes.
Okay.
We've also put together, I think as Jeff Pierce may have noted, that our enforcement process improvements are underway. One of the things that we've also pulled in with that is as we've started to lay the groundwork for the streamlined administrative resolution program for certain types of cases, also looking at pulling and sweeping in the process for late fine review and collections from all programs into our fines collection officer area of work, so that again we can create consistency across programs and establish clear and expected and predictable timeframes for when people can hear from us. I appreciated Mr. Lee's comments earlier, and we'll be following up with him directly on questions that he has about the timing of when he received a response or didn't. So we'll be on top of that to make sure that we can identify and resolve whatever issues might have come up there. We have made progress on our audit program. The publicly financed candidates from the 2018 election, those are being conducted as assessments through our external auditors. We're on the phone with them yesterday and are seeing good progress and reports that will be coming forward and being finalized for the public and then posted once that's once they have been finalized. And we've completed all 27 campaign audits from the 2016 election cycle. There are additional 11 discretionary audits being conducted as we speak with our audit staff internally. And we are targeting completion by the end of the fiscal year to make sure that we can stay on top of those. We also are focused on dedicating resources on the audit staff this year to establish a lobbying audit pilot program so that we can actually fulfill that obligation under the law. We have not been able to do that with the resources that we've had in the past several years.
So Director Pelham, would it be, I would find it very helpful, and I hope my fellow commissioners would as well, if you could brief us on the audit program that as it currently stands and the resources that we have deployed in this area, because auditing the publicly financed campaigns as well as the 11 other discretionary audits that are conducted, how are those things going? What are the opportunities for improvement? What are the resources that would be needed in order for us to become even more effective and efficient? I think it would be helpful to ground us in what we currently do, the scope of the work, and where we would like to go, as well as the learning more about what the lobbying audit pilot, would encompasses. I think that would be really helpful to have an overview of all that work. And it could help inform, I think, the budget discussion as well, because always a challenge for resources.
We look forward to doing that at an upcoming commission meeting. Thank you. I've attached to this report also a report that I provided, I think in mid-2018, but it's an update from, and I see in very small print, so I apologize for that, for those of you looking at it in hard copy, but a project status update on our electronic disclosure and data analysis division work across the range of areas that are impacting our operations, our public disclosure programs, our filing systems to help people comply with their obligations under the law. And so there's information, there's information here about the variety of specific initiatives broken down by area. I wanted to just provide that to you. And Gayatri, whose engagement and compliance team is working very closely with Stephen and others on the electronic disclosure team, are all helping to make sure that this stays on track this year. We can certainly provide any more specific information that you might be curious about for any of these programs. We're always encouraging Stephen Massey to do presentations, and so if there's, by popular acclamation, needing Stephen to be here, we'd also happy to bring him to a next meeting to walk through some of these highlights and what we have on tap for this year. It is quite an ambitious project, and as you know, we really need to stay focused on making progress in this area because much of it is funded by money that came through the Commission on Information Technology, or COIT, in the city. And so we have very specific deliverables by specific dates. We're working with our vendor to try and make sure that we also have deliverables identified that they can help produce to keep our systems as effective as possible within the constraints that we have. So it's a lot of information, but I think I wanted to present it because it does give quite a flavor for the breadth of work that we are doing to fulfill that goal of having our systems not paper-based, but electronic. And then we also know from that's not where the work stops, but the work then continues on with Gayatri's team and engagement compliance to make sure that the public has the information that we provide in an electronic format, and that the public also knows where to go to get information, to your point that it's not something that they have to necessarily come to see us, but that we can push out information in constructive ways. So I think we're also looking at how we can be much more visible in various communities through some of the projects that are identified here in the coming year.
And to that end, I think that Commissioner Lee speaks frequently about the importance of reaching out to the community, and I would like to just throw out the idea of, for lack of a better term, an Ethics Commission roadshow to go out to the community to explain what we do and to make sure that people know who to go to, what they can expect from the Ethics Commission, and if they have questions, where they can find the answers on these, and that there's a treasure trove of information that Stephen Massey and Tyler have really put at our fingertips in a very easy to use and navigable and very impactful visual way. And so I think sharing that and getting that message out will be I think, very profound, I think, for a lot of communities. So if we could look to do something, design it, I think I, through your team, would be really instrumental in designing something that would be an overview and meaty enough and meaningful enough for a community, for, varying communities of different stakeholders, I think could be very powerful.
I also wanted to highlight and introduce to you the newest member of our staff. I did mention in this report that we were very sorry to see Nikkei Andino move on, as many of our temporary as-needed staff do. He was able to move to a permanent position, a promotional position within the Department of Public Health. And Nikkei was here for, I think, 10 months, and again, just did outstanding work, and we were sorry to see him go. But in record time, in only 3 days later, we had our senior clerk
To be a record.
position filled due to much hard work on the part of Gayatri and Adam Romoslawski over in DHR as well. But Ronald Contreras is here. I wanted to just ask him to stand in the back of the room. Ronald started with us on November the 6th as our new senior clerk in the engagement and compliance team. And so his is the voice that you will be hearing when you contact the office. It is a very chipper voice and a very energetic voice. And so we're very excited to have him on board and to welcome him. He has a tremendous amount of experience, having been with the city of Denver, including at the airport for a number of years in a variety of capacities. And so we're really looking forward to just leveraging every ounce of that as he's joined our staff. So I just wanted to make sure that we could introduce and have a face with a name.
Wonderful.
For you, so.
Well, I want to say thank you to Nikkei for all of his great work and his never, ever cheerful and super helpful demeanor and attitude on the phone and in person, and I want to wish him the best in his new role with the Department of Public Health. And welcome, Ronald. Look forward to getting to know you and working with you in the coming weeks and months.
Welcome. I won't hold it against you with all the time that I got stuck at the Denver airport.
and lost luggage.
Okay, we won't go there.
Yeah.
And I guess two last items. Maybe three last items. On table 2, you'll see the list of position vacancies. More good news on that front. I believe Monday, I'm going to go out on a limb and say that I think it is Monday that we will have a position posted for our investigative analyst in the enforcement division. This will be that open investigative seat that we very much are looking forward to filling in Jeff Pierce's team. And because of the Thanksgiving and year-end holidays, we are going to planning to post that for a 4-week period rather than 3 weeks. We really do want to try and get the word out and give people ample opportunity to make sure they get applications in so that we can bring somebody on board to fill that seat. Pat Ford mentioned Kogel. We are very determined and aggressive about wanting to use our travel resources, our training and travel resources to get employees to places where we can all absorb and learn from our peers and share information, as Pat and others will be doing on panels this year. So this year we do have a good handful of people going to the conference, and I think that's an important thing to do for all of us to keep current in the issues, to learn from best practices, and to share what's happening in San Francisco, because there's a lot of work underway, as you well know, with what the work that the Commission's been doing this past year. We are also likely not to attend Kogel in coming year, perhaps 2. There are conferences that have been established 2 or 3 years out, but some of them are in jurisdictions where the city has established a no-travel policy because of policy issues that are happening in those jurisdictions. And so we will be following the lead on that, obviously. So I think it's timely to be able to send employees to this conference in Chicago. Next year there is a conference in Georgia, and that is a state that we will not be traveling to, even if it's on our own dime, because that would involve city time. So we'll learn as much as we can and come back with all that we can to share with our colleagues here in the office and with you as well. And then lastly, I would just note there was I think a discussion about an audit. After this week, I guess, it was early this week, I received information that Board President Yee had introduced or had requested a performance audit of the Ethics Commission. Chair Chu and Commissioner Lee and I met with him yesterday to have a general discussion about budget and also to learn more about the audit request. And it appears, as we understand it at this point from Supervisor Yee, that as part of the budget and legislative analysts' work plan for this fiscal year, the Ethics Commission will be added as a priority performance audit to a list of other sort of high visibility, high priority projects. And so, as we said to him yesterday, I myself come from a background of performance auditing, and I think audits are our friends. So I'll be reaching out directly to the budget and legislative analyst to offer whatever assistance we can in figuring out timing and scoping and how we can be resourceful and assistance to them in doing whatever work they've got on tap. So we will report back to you when we learn more, but I just wanted to make sure you were aware of that, since that's something that wasn't in my report, since I had got information about that after it went to press, as they say. But I'm happy to answer any questions if you have any, or provide any further information as needed.
Other questions from commissioners? No? Wonderful. Thank you. Public comment on this item? No. Okay. Agenda item number 9, discussion and possible action on items for future meetings. Any other things that the commissioners would like to put on the agenda? No. Public comment on agenda item number 9? And agenda item number 10, additional opportunity for public comment on matters appearing or not appearing on the agenda pursuant to Ethics Commission Bylaws, Article 7, Section 2. Okay, there being no public comment, motion to adjourn. All right,
I'll move.
right, we're adjourned.